So this last hour is focused on environmental related topics. We'll look at pesticides at the waters of the United States and at Chesapeake Bay issues. Our presenters for this session are Chloe Marie, a research specialist at the center, and Brook Duer, our staff attorney. So Chloe, turn the floor over to you. Thanks.
Yeah, sounds good. Thank you, Ross. All right, so before I start, So last year during the 2021 Farm Symposium, I addressed the new registration of 3 dicamba products and their practical implications, as well as the status of legislative and regulatory actions and litigation related to the pesticide Chlorpyrifos. So now that we're beginning the new year, it is time to touch base and see what has happened during the course of 2021. And for those of you who did not attend last year's symposium, you can access this presentation on our YouTube channel or by directly clicking on this link. So let's start this presentation with the herbicide dicamba. And first, a little bit of background. So in October 2020, EPA approved the new registration of 3 dicamba products, Bayer's XtendiMax, BASF, Engenia, and Syngenta Tavium. EPA directed that the approved product registrations are unconditional or for a new use on dicamba tolerant soybean and cotton only, that they apply only in 34 states, including Pennsylvania. They will expire on December 20, 2025. They prohibit soybean application after June 30 annually. They also prohibit cotton application after July 30 annually. And they limit the state's authority to impose further regulation on pesticide use. And about that last requirement, Section 24C of FIFRA allows states to amend annually federal pesticide labels based on their special local needs. It can include agricultural, environmental, and or public health needs, as long as their regulations are stricter than the federal ones. And over the years, states have often used this provision to expand or limit pesticide uses. But EPA changed its interpretation of Section 24 and now imposes states to regulate pesticide use through state legislature or rulemaking procedures as set out in Section 24A of FIFRA. So states criticized this new interpretation as not only creating a burden on states, as amendment procedures are less cumbersome than going through a rulemaking process, but also infringing on the state's ability to require additional restrictions on pesticide use. And very recently, on December 21st last year, EPA published a report on the impacts of the use of over-the-top dicamba on non-target crops for the 2021 crop season. And in a related press release, EPA wrote that despite the control measures implemented in EPA's October 2020 dicamba registration decision, the 2021 incident reports show little change in number, severity, or geographic extent of dicamba-related incidents when compared to the report the agency received before the 2020 control measures were required. EPA also stated that it is reviewing whether over-the-top dicamba can be used in a manner that does not pose unreasonable risk to non-target crops and other plants or to listed species and their designated critical habitats. But more importantly, EPA announced that it is considering further regulatory action. However, it warned that the regulatory tools that the agency could use to address the extent and severity of the alleged dicamba-related incidents are unlikely to be fully implemented by the 2022 growing season due to the statutory processes the agency is required to follow. So on the litigation side, multiple challenges were filed against EPA in both federal court of appeals and federal district courts to invalidate the dicamba registrations. So a first lawsuit was filed before the Ninth Circuit Court of Appeals in December 2020. The case opposed four nonprofits: the National Formerly Formed Coalition, Center for Food Safety, Center for Biological Diversity, and Pesticide Action Network against EPA. Petitioners asked the court to vacate their registrations after alleging violation of FIFRA and the Administrative Procedure Act. They argued that EPA could not provide substantial evidence in reaching its decision that the registrations will not cause unreasonable adverse effects on the environment, and that EPA neglected to provide notice and an opportunity for public participation before authorizing a new use of the pesticide. And therefore, EPA's restriction placed on the authority of states to further regulate pesticide use is flawed. So at about the same time, petitioners also filed a parallel lawsuit in the Federal District Court of Arizona, which mirrors the same claims as the ones argued before the Ninth Circuit Court. The reason for filing this lawsuit was that there was still some uncertainty as to the subject matter jurisdiction of the Ninth Circuit Court. And in their complaints, plaintiffs argued that EPA failed to fully consider the social and economic risk and cost to farmers posed by the new registrations. Another of their complaint is that EPA issued unconditional registrations. Unconditional registration requires EPA to determine that the pesticide product operates properly without causing unreasonable adverse effects on the environment and performs its intended purposes. But here EPA allegedly failed to assess the difficulty for farmers to realistically both follow the label use directions of the products and control noxious weeds. And in addition, they stated that EPA's blatant move to get rid of state authority under Section 24C of FIFRA to further limit the use of a pesticide is arbitrary and capricious and should have gone through the formal rulemaking process to change the rule. So for all these reasons, the four nonprofits asked the district court to vacate the 2020 registrations and stop the sale and use of the products. However, in January last year, the lawsuit that was filed before the Ninth Circuit Court was transferred to the US Court of Appeals for the DC Circuit and was also later consolidated with a case filed in the same court by the American Soybean Association, which challenged the Dicamba registration on different grounds. While the first lawsuit argued for nullifying the Dicamba registrations, the lawsuit filed by the American Soybean Association argued for expanding the registrations, alleging that the current use limitations are too prohibitive for effective use of the Dicamba products. So both parties raised the issue of jurisdiction and whether the case should be heard in the Federal Court of Appeals or the Federal District Courts. And in August 2021, plaintiffs filed a motion to determine jurisdiction before the Federal District Court of Arizona. They argued that the case should be litigated in Federal District Court because EPA failed to hold notice and comment on the 2020 registrations and therefore did not hold a public hearing. And as reminded by plaintiffs, the appellate court jurisdiction only applies to cases involving the validity of any order issued by EPA following a public hearing. So they subsequently filed a voluntary motion to dismiss the case before the DC Circuit Court, which was later granted. But very recently, in November last year, the Federal District Court decided otherwise, and it denied their motion to determine jurisdiction. The court also ordered to stay the case proceedings to allow additional time for resolution of the issue before the DC Circuit Court. And only some days ago, the nonprofits filed a motion in district court to lift the stay following EPA's release of the December 2021 report I just mentioned on damage caused by using the pesticide Dicamba. They wrote in their motion, quote, "All parties agree that district courts are the proper jurisdiction for review of the 2020 registrations. Thus, lifting the stay and allowing the present litigation to proceed is necessary to protect plaintiffs' interest, U.S. agriculture, and environment, and will not prejudice or cause any hardship to the other parties." So if you would like to stay informed on the development of this matter, I highly recommend you check our Dicamba issue tracker that is available on our website, where we do our best to keep you updated on many agricultural legal topics. So now let's move on to our next and last pesticide topic, Chlorpyrifos. So some of you may have heard on August 30, 2021, the US EPA made a major announcement for US farmers by prohibiting all tolerances for residues of Chlorpyrifos on specific food and feed commodities, effective February 28, 2022. So this decision is the result of years of litigation opposing environmental organizations against EPA over the health and environmental risks associated with the use of this pesticide for agriculture. So this decision was made in response to a court order that was issued in April 2021. But before addressing that court order, let's go back in time for a moment. So Chlorpyrifos is an insecticide used to control termites, mosquitoes, and roundworms. It was used in residential areas, but has been banned in 2000s because of the associated risk posed to infants and young children. However, its use was still allowed on a variety of food and feed crops and is registered with EPA as a pesticide. And Chlorpyrifos was last registered in 2006, and its registration is currently being reviewed by EPA with a statutory deadline set on October 1st, 2022. So in December 2020, as part of the registration review process, EPA issued a proposed interim decision and recommended the continued use of Chlorpyrifos, but with the implementation of new risk mitigation measures. So now the use of Chlorpyrifos has been challenged in courts on many occasions, and the issue dates back to 2007 when the Natural Resources Defense Council and Pesticide Action Network North America petitioned and requested EPA to revoke all tolerances and cancel all registrations for Chlorpyrifos under the Federal Food, Drug, and Cosmetic Act. They pointed out the dangerous nature of Chlorpyrifos based on many scientific evidence and its adverse health effects on children and infants. EPA repeatedly delayed its final response to the petition until March 2017, when EPA denied the 2007 petition by stating that the petition fails to provide a sufficient basis for revocation in the absence of quantitative data. And later in July 2019, EPA denied objections raised against its 2017 decision. So in August 2019, a coalition of environmental organizations filed a petition before the Ninth Circuit Court seeking review of EPA's 2017 and 2019 orders. The case was later consolidated with another case filed in the same court by a group of 6 states that include New York, California, Washington, Maryland, Vermont, and Massachusetts. The states argued that EPA failed to meet the statutory standard for pesticide safety. The pesticide standard provides that EPA, quote, when leaving in effect a tolerance for pesticide chemical residue, must ensure that there is a reasonable certainty that no harm will result to infants and children from aggregate exposure to the pesticide chemical residue. So on April 2021, the Ninth Circuit Court of Appeals vacated both orders and directed EPA to either modify chlorpyrifos tolerances or prohibit them. The Ninth Circuit Court stated, quote, "In short, the EPA has spent more than a decade assembling a record of chlorpyrifos ill effects and has repeatedly determined that it cannot conclude that the present tolerances are causing no harm." As a result, EPA prohibited last August all chlorpyrifos tolerances for food commodities effective February 28, 2022. EPA concluded that the current aggregate exposures from use of chlorpyrifos do not meet the legally required safety standard, that there is a reasonable certainty that no harm will result from such exposures. The agency also noted that it is committed to reviewing replacements and alternatives to the pesticide. So now what this rule means, practically speaking, is that chlorpyrifos can still be used on food commodities until February 28, 2022, and that food treated with chlorpyrifos before that deadline will not be considered contaminated. After that, food treated with chlorpyrifos will be considered as such and will not be distributed in commerce. And know that use of chlorpyrifos for non-agricultural and non-food uses is still allowed and is being reviewed as part of EPA's registration review. So about the impacts on US farmers and food producers. On October 19, 2021, more than 80 producer groups filed a petition with the US EPA challenging the agency's revocation of all chlorpyrifos tolerances. The petition cites examples of sugar beet growers, soybean farmers, Michigan cherry producers, and others who stand to experience substantial economic loss resulting from their inability to use chlorpyrifos, which according to them provides the most effective pest control for their crops. The groups argue that EPA wrongly determined the rule to not be economically significant, and as such failed to seek its review by the Office of Information and Regulatory Analysis. In addition, the groups argued that in revoking all chlorpyrifos tolerances, EPA only identified a potential hazard that EPA's own experts believe can be mitigated using existing controls. So the groups are asking EPA to rescind the rule and stay its implementation, but EPA has not yet answered their petition. So hopefully this is not too much to digest, and in the meantime, we'll make sure to provide you with the best information on this issue on our website. All right, so now let's switch to another very important topic and discuss the waters of the United States and the litigation surrounding its definition. So how the government should define waters of the United States has long been discussed and intensively litigated. So each presidential administration had a say in the designs of the definition. But for the purpose of clarity, I will only concentrate today on what happened in the last year since President Joe Biden took office and how the courts were involved in setting the stage for the latest version of a proposed definition of waters of the United States, which Brook is going to talk about in the rest of this presentation. So as a little reminder, on January 25, 2021, President Joe Biden issued an executive order and required a review of the Navigable Waters Protection Rule that was issued in April 2020 under the Trump administration, and which became effective on June 22nd, 2020. And in this respect, EPA and the courts announced their intent on June 2021 to revise the definition of waters of the United States as directed by President Biden. And in their press release, they wrote that the current definition has resulted in a 25 percentage point reduction in determinations of waters that would otherwise be afforded protection. and that there is a need for a durable definition in line with the purposes established in the Clean Water Act. So on the same day, the US EPA and the Corps filed before the US District Court for the District of Massachusetts a voluntary motion to remand without vacatur the Navigable Waters Protection Rule back to the agencies. This means that the rule would remain in effect while EPA and the Corps engage in a new rulemaking process to revise or replace the rule. The Navigable Waters Protection Rule has been challenged on multiple occasions, and most courts agreed to remand without vacatur the rule back to the agencies. However, in addition to the remand, some also decided to vacate the rule pending the Corps and EPA's new rulemaking process. So that is the case in the Pascua Yaqui tribe versus US EPA litigation that was filed before the US District Court for the District of Arizona. The tribe filed a complaint against EPA in June 2020, requesting the court to vacate and set aside the 2019 repeal rule, which repealed the 2015 Clean Water Rule, as well as the Navigable Waters Protection Rule, and to reinstate the 2015 Clean Water Rule. So in August 2021, the Arizona Federal District Court granted their request as to the Navigable Waters Protection Rule, but did not rule on the merits of the 2019 repeal rule. As a result, the court reinstated the pre-2015 regulatory regime, pending resolution of the 2019 repeal rule challenge. And as part of its reasoning, the Arizona District Court considered the seriousness of EPA's errors in enacting the Navigable Waters Protection Rule, the likelihood that EPA will alter the rule, and the possibility of serious environmental harm if the rule remains in place upon remand. The court found that all three factors weighed in favor of vacating the 2020 rule. The court wrote that there are substantial concerns about certain aspects of the rule, including whether the rule adequately considered the Clean Water Act's statutory objective and the effects of the rule on the integrity of the nation's water. So this case is significant in that following the court order, the Corps and EPA announced in September 2021 a nationwide stop on the implementation of the Navigable Waters Protection Rule, and that the interpretation of waters of the United States should be consistent with the pre-2015 regulatory regime until EPA drafts a new definition of waters of the United States. However, in October 2021, multiple industry interveners filed an appeal before the Ninth Circuit Court of Appeals, seeking review of the district court's decision to vacate the rule. They also filed a motion to stay the district court's vacatur pending the appeal, alleging that the rule vacatur and the return to the pre-2015 regime pending issuance of yet another new rule by the agencies will be unduly disruptive to the regulated community, which far exceeds any speculative injury asserted by plaintiffs. In December, very recently, the Corps and EPA filed a motion to dismiss for lack of jurisdiction the appeal filed by industry interveners. They stated that the district court's order vacated one of the two rules challenged by plaintiffs and remanded to the agencies, but the claim challenging the other rule remains pending in district court, so the order is not final and appealable. Indeed, just like I have already mentioned, the court has not yet decided on the merits of the 2019 repeal rule. And in addition to that, the motion stated that the orders remains to the agencies, and remand orders generally are not final as to interveners. And finally, the order is not appealable by the interveners as an injunction because the order does not require interveners to take any action, nor does it prohibit them from doing anything. So subsequent to that, on January 4th, 2022, the industry interveners filed a motion for voluntary dismissal of appeal that was granted yesterday by the Ninth Circuit Court. And because the courts have not already decided on the merits of the 2019 repeal rule, there is likely going to be more litigation to come. All right, so for those of you who want CLE credits, the CLE code for today's session is water. So thank you all for your attention. I know it was a lot, and I will now hand the floor over to my colleague, Brook.
Thanks, Chloe. I'm just trying to hit all the buttons here and get myself situated. Give me 1 second here. I have to say that you got stuck with the hardest part of all of this and the most brain-numbing part. Give me a moment here. Okay. Okay.
Yeah,
I think we should be. Are you seeing my screen?
Yes, I can see your screen.
Okay, so Chloe said something in there that was sort of key to understanding all this, which is that you know, there's I guess the best way to think about it is there's 3 separate regulatory schemes that existed. Everything that existed before the 2015 rule, then what existed in that period between 2015 and the repeal of the 2015, which also reinstated all of the things that existed before 2015. And so when the Navigable Waters Protection Rule is then promulgated, challenged, and stayed, then the and or vacated, depending. Okay, so and remaining under appeal, then it didn't revert to the 2015 rule because that had been repealed, and so it reverted back to the pre-2015 regulatory scheme, which interestingly seems to be at least better than any of the other options for both sides, barring the Navigable Waters Protection Rule, surviving this whole challenge. So this idea that the thing that Chloe was referring to that resulted in the dismissal of that last case she was talking about is the quirk of this whole thing, which is in previously the 2015 rule, and we could call it the Obama rule because that's what it's been called, and it certainly was his administration, that the Obama rule was completely and totally repealed, and that action stands. And with the dismissal of that case, that action stands. So we now are only talking about either we have the pre-2016 regulatory regime or we have the Navigable Waters Protection Rule. And that's really the 2 choices. And the current administration, so what do they do? For the, in order to proceed ahead with their own creation, so to speak, or their own definition, they're starting by just taking the pre-2015 regulatory regime that the Trump administration had put in place right before the Navigable Waters Protection Rule. That's what the current administration is now seeking to promulgate as the permanent. And if, they're racing against the clock, perhaps, to try to get that done to render a lot of this moot. But it becomes ironic that essentially the current administration is seeking to have made seeking to make the same regulatory regime that the Trump administration at least lived with until they had the Navigable Waters Protection Rule promulgated. So you get some sort of like strange alliances here in this situation. Hopefully that may make some degree of sense to you. The bottom line is, no matter what happens, unless the 2019 repeal of the Obama rule is challenged, is successfully challenged in some way, that's no longer an option. I guess I'll just put it that way. So again, I gave you the preview there, which is I sort of already indicated that at November 18 was when the current administration essentially took all of the pre-2015, the pre-Obama rule regulatory regime and regulations, and they proposed those as their proposed rule to go forward. Now, how many years this is going to take? It was proposed on November 18, and there's all sorts of things going on, like these public hearings, and there's one more of those to happen. How long that's all going to take to become a final rule, I guess we will find out. Then so here's where we're at now, and this is again a proposed rule, but it is putting in place essentially that which the administration is already using, because the court has vacated the navigable waters protection rule, and the fallback is the pre-2015 provisions. So they're essentially seeking to promulgate that which they're already following at this point in time. Okay, I think I'm going to pass on that because I have so much other material to cover, or I'll put it this way, I'm going to pass on going through great detail here. I think the key is to understand, let me see if I'm going to go back to this page. Okay, so this is, we all know that once a regulation is promulgated, this could take, any number of years to, become a final rule. Even in a rocket docket where the administration is highly motivated to push it on through, this is going to take some amount of 2022, if not all of 2022, to get to, to become a final rule. Then the $64,000 question is, will this administration then start over again with another rule, which is not the residue of what existed prior to 2015, but is a rule of its own creation? Because what they're promulgating here right now isn't really a rule of their own creation. And I've seen differing language used in some of the, particularly on the EPA's website, about whether they're going to take two bites at this, so to speak, by they want to clear the air by reinstituting as a final rule the pre-2015 regulatory scheme, and then potentially start at it again, which tells me that, I don't know how many years, they're planning on, but the clock could run out before, even on a two-term president, before you get all that done. I'm probably being more facetious than serious there, but it's brain numbing, how we've gotten to this point. And I guess all I'll add to that is that while we have more peace than we had before at this moment in time, we also have dug up so much cause for argument by arguing over the significant nexus and this and the continuous, connection to the surface waters, et cetera, that I don't know how much what's the right word for it? It's not. Obviously does not have to be unopposed and unanimous or bilateral or consented to by all. But I think we've actually probably spent these last few years creating more basis for arguing about what should be the proper definition than quieted down the argument so that everyone can zero in on, just a few points that are in dispute. We probably have more points in dispute now than we've ever had with regard to what should be the proper definition. So I think it just raises the question of how successful can this administration be in bringing peace to this area. So with that, I will go and proceed to the next topic on my agenda, which causes me to have to go backwards in the PowerPoint. So excuse me for a second. Okay, now we're going to talk about two issues related, Chesapeake Bay and the Conowingo Dam. And this, hopefully we'll have enough time to cover this and maybe get a few questions in there. All right, Chesapeake Bay developments. Last year, we had this program, and Professor Laura Fowler from the law school was involved as a presenter talking about Chesapeake Bay issues, as well as Paul Geringer from University of Maryland's Extension Service, who does a similar, ag legal. He's an attorney, does a ag legal education similar to what we do at the Ag Law Center. And what we talked about last year was that several things were cooking at that time. There was a lawsuit that had been brought by several states against the EPA, Maryland and Virginia primarily, in trying to essentially create a cause of action or have a cause of action recognized that EPA was not policing, particularly Pennsylvania, but also New York's, compliance with the 2025 TMDLs, and that EPA was essentially shirking its duty under the Clean Water Act. That was one thing that was happening last year, was talked about. In addition, the other thing that was happening last year that was talked about was the Conowingo Dam and the role that the Conowingo Dam plays in this, in the issue of nutrients and sediments exiting into the Chesapeake Bay, and the fact that the dam was up for relicensing. And since that time, since last year's presentation, we do have significant developments on that particular front. Now, third, let's just talk about the third issue, which is generally the Chesapeake Bay's health and progress towards meeting the TMDLs set that are to hit the targets for 2025. And so let's talk about that particular issue first, and then we'll go to the other two issues. Now, on general topic of particularly Pennsylvania's compliance with the TMDLs and its obligations with regard to the Chesapeake Bay as theoretically enforced by the EPA. In December of 2021, DEP released a report, which normally would get a little bit of press, but this time did not, and there was a reason for that, called Pennsylvania's 2020 Chesapeake Bay Progress Report. And there's been a series of these reports every year around this time. I don't know how late this one is, but I think it's generally in the time frame when this yearly report from DEP would be published. But this one came out and no one talked about it. There was no press release, there was no nothing. And it was telling a good story to the extent that a good story can be told. Said that Pennsylvania reported more than 4 million pounds of nitrogen reductions to EPA from just in the year 2020, which of course is we're a year back, so presumably more in 2021. And more than 2 million pounds of that came from ag and the wastewater sectors. And the report was, calling Pennsylvania is at an unprecedented turning point in improving its share of the Chesapeake Bay watershed. Other progress points were that 4 counties had completed what they're calling the countywide action plans, these CAPS or CAP, and there's a total of, I think, 34 counties, I think, that have to that contribute to the Chesapeake Bay watershed. So do the countywide action plans. 4 more did countywide action plans that were implemented in 2020, and then 4 also had done that in 2019, bringing to 8 the number of counties that had begun carrying out their county action plans. 26 more counties agreed that at least they need to get moving and begin implementing their countywide action plans in 2021. So that would constitute all 34 counties that are to do the countywide action plans. That was viewed as a positive development. That is the sort of the next step in the WIP for Pennsylvania, the Watershed Implementation Plan. And so that was a positive. Here are some of the statistics that were put into the DEP report. And this, obviously the state funds invested, that's always the issue with the Chesapeake Bay, is where are we going to come up with the money for the programs, and and how will that money be spent? Will there be direct grants? Will there be some other form of economic encouragement in other ways to ensure that individual farms are doing their part? Here gives you some of the numbers in terms of 17.2 stream miles fully restored, 16,000 acres of grass buffers, 300,000 and some change acres with enhanced nutrient management, 538,000 acres of cropland in compliance with nutrient management and manure management plans. So all good things, but why didn't this receive publicity like it might normally have? Well, just a few days after we crossed out of December into January, the Chesapeake Bay Foundation released what is somewhat a scathing report on the state of the blueprint for repairing the bay, and particularly singling out Pennsylvania for some very, I don't know if I'd call it harsh treatment, but in any event, this certainly got picked up by the national press and ran all over the country. Pennsylvania remains far off track, threatening the blueprint success, and equally as important, the ability to restore its local waterways. Getting the Commonwealth on track is essential and will require a massive influx of technical and financial assistance to provide farmers the resource to implement conservation practices. Perhaps all accurate, massive influx, probably an agreed upon characterization of the financial needs of what has to be done. It does cite the 4 million, despite reducing over 4 million pounds of nitrogen in 2020. Pennsylvania is not on track to achieve its 2025 nitrogen and phosphorus reduction targets and the sediment targets, although nitrogen and phosphorus and sediments are clearly the secondary issues. And the Commonwealth is significantly behind in implementing the practices necessary to close the gap. More than 90% of its remaining pollution reductions must come from agriculture. Here is a chart that gives you a little bit of a comparison of the various states. And this is sort of the kind of things that really whipped up the national press in covering this. Obviously Pennsylvania on top here, and okay, off track with regard to the wastewater treatment plants. These point sources, these point sources that are connected to wastewater treatment plants, that's or other wastewater, that is on track for nitrogen and phosphorus, not on track for urban and suburban runoff, not on track for agriculture, and off track with regard to septic tanks. And so overall rating of off track, and on phosphorus in danger of being off track. Now, as you see, Maryland and Virginia both received a much better report card, so to speak. And again, more somewhat, significant and shall we maybe say inflammatory language about Pennsylvania remains, far off track. And I think actually it was not the same quotes that I had in the other last slide. Sorry about that. I think I decided to move them and did not delete them from here. The other sort of singling out, there's a section that deals with each individual state. And here's some singling out of Pennsylvania with regard to some of the specifics of being off track and what might need to be done to get on track. So the bottom line is DEP obviously knew this was coming, and it wouldn't have looked probably that good to be touting the other report when this one was about ready to be released and was so negative. So I think that explains exactly the sequence of this and how this exactly happened. So that gives you some general information. Now, let's talk about the lawsuit. This lawsuit that was filed, and you may recall that this was a very interesting dynamic where Governor Larry Hogan in Maryland ordered publicly through a press release and a press conference that the Maryland Attorney General, who's an independently elected official, sue EPA over Pennsylvania's noncompliance. And it may have mentioned New York in there, but that was sometime in 2019, I think it was. And it took a while, but eventually this lawsuit did in fact get filed. And Maryland also was joined in it by Virginia and Delaware and the District of Columbia. Now, they actually filed separate complaints. It's all been consolidated since that time. And I'll just tell you that in terms of an update, although Pennsylvania is not a party to this case, the case and its outcome could have some very significant ramifications for Pennsylvania and needs to be continually watched. The EPA filed a motion to dismiss, and that was last year. That remains pending, and the basic theory there is that there isn't actually an agency action to appeal to the DC Circuit here, and that is why EPA says the case should be dismissed. Actually, no, these are not circuit. Sorry, this is agency action. In this case, it would be going to the district court. Sorry about that. And there's no final agency action. Technically, it's simply an inaction or a failure to act. Generally, that has not met with good results under the Clean Water Act and the establishment and enforcement of TMDLs. For example, there was an attempt to force a establishment of a TMDL for the western portion of Lake Erie by the city of Toledo, which was dismissed on a similar theory to this one, which is that there was not a cause of action for the failure to act under the Clean Water Act in these types of circumstances. In that case, it was the establishment of a TMDL. In this case, it's the enforcement of a TMDL. In any event, EPA's consistent position has been that they defend these cases by saying, this is what we're doing. We're following the Clean Water Act, and a federal court can't tell us that we have to do something more than that. So far, that's been relatively successful, although I'm sure maybe there's somebody out there who knows of a case where that argument hasn't flown, perhaps. Now, let's talk about the other two issues that I mentioned, the Conowingo Dam relicensing, and also the Conowingo Dam has its own WIP, its own watershed implementation plan, which we'll get to in a minute, which is a unique animal, which we did not really talk about last year. The Conowingo Dam relicensing, at the time of our last year's session, and our last year's sessions are all available from our website. The videos are there for watching. On March 18th of this year, FERC, who is the federal entity that would license the hydroelectric plant at Conowingo. And just for those who may not be aware, Conowingo is a dam, a hydroelectric dam built by and operated by somebody, now owned and operated by Exelon. It was built in 1928. It is, completely dams the Susquehanna River in Maryland, approximately 10 miles above the entry of the Susquehanna to the Chesapeake Bay. So very unusual physical layout that you would have such a large body of, or such a large, entire Chesapeake Bay watershed draining into the Chesapeake Bay and have a dam at the bottom of it. Not the kind of thing that you would think would ever be attempted in today's world. Could you imagine if the Mississippi River had a dam at the bottom? In any event, the relicensing, we knew it was coming, or it was telegraphed it was coming, because there had been lawsuits and litigation about this previously, and there had been a settlement of those lawsuits where Maryland and Exelon essentially settled based on an agreement to relicense the dam. And it went forward and it was approved by ERC. The settlement agreement was approved in the FERC licensing proceedings. So in fact, the license was reissued for another 50 years to maintain a dam at the bottom of the Susquehanna River. I know those who live closer and maybe see the sense of this, but I think the further away you get, the more it seems to be a rather absurd physical setup here, that anyone would permit a dam such as this to exist, particularly under the circumstances that we are in today. But be that as it may, I'm not a utility attorney, and electric utilities and the courts have their own relationships, and FERC has their own jurisdiction. In any event, the part of this licensing that has everybody completely whipped up is that Exelon, who has profited from the existence of this dam, is only required to pay $200 million towards Chesapeake Bay cleanup, and that's really a you can call it what you want. It could be considered a inadequate amount. Let's say some might call it a drop in the bucket. Some might call it they got away with basically no obligation. In any event, that has the Chesapeake Bay Foundation, as well as 20 other interveners, fuming mad, and that has resulted in an appeal to the DC Circuit. And so the DC Circuit is now sitting on an appeal from ERC's decision, and statutorily, I guess it goes to the circuit court in this particular case rather than the district court, as some things do. And so this 50-year license is now the subject of an appeal, and the case is called, I think the lead plaintiff, here's the caption, the lead plaintiff is Waterkeepers Chesapeake. So it's called Waterkeepers Chesapeake versus FERC et al. Now, there was also, by the way, in addition to the appeal from the the March 18th relicensing, there was an initial June appeal. There was also a request for a rehearing, and then there was an appeal. There was an opinion issued on the rehearing, which was another 30 to 50 pages of reasoning on why the license was being reissued with very little obligation for the Chesapeake Bay cleanup. Now the two cases are consolidated. Whoops, excuse me. Now the two cases are consolidated. The action in this particular legal proceeding, the relicensing appeal, is that there has been a briefing schedule now set for the substantive disposition of the petitions for review, the two, and that occurred on I think it was October 8th was when the briefing schedule was set on November 19th. And so November 19th, the briefing schedule was set, and here it is. So we're looking at final briefing on the petitions on the relicensing done in June. So we're looking at maybe towards the end of 2022 or into 2023 before we hear about the Exelon relicensing and whether it's going to be upheld as is with this comparatively lesser amount or a disappointing amount of 200 million. And again, this maybe I have neglected to mention that, of course, the Conowingo Dam has been adjudged to have become at its maximum ability to hold the sediment and nutrients that are behind it. And so that every time there is a rain event now, that legacy sediment that is behind the dam, which may have arrived there decades ago, up from the upstream runoff and tributaries into the Susquehanna River, that old sediment and nutrients washes over the top of the dam. What does that cause? Well, that causes a complete reassessment of the TMDLs that were established way back in 2010 for cleaning up the bay, because now there is essentially, in the number that has been identified, it's about 6 million pounds of nitrogen and 260,000 pounds of phosphorus that need to be accounted for, that are entering the bay, that were not assumed to be entering the bay back when the TMDLs were set in 2010. So the TMDLs, in other words, won't take care of the whole problem. There's an additional 6 million pounds of nitrogen and an additional 2,600 pounds of phosphorus that need to be accounted for. Well, who's going to deal with that? Well, that's what the Conowingo Watershed Implementation Plan is all about. And what that is essentially, once it was recognized that the dam's ability, or maybe we'll just say the static nature of what was behind the dam was recognized as no longer stable, and that it was now contributing a new load to the Chesapeake Bay that wasn't recognized before. And that load, while it is caused by a dam that is located in Maryland and is operated by a utility that has profited from the existence of the dam all this time, the way this is being approached is that this is everyone's burden to share. Now, you can disagree with that approach if you wish. I might personally disagree with that, but that is the way it is proceeding. So in other words, this is not Maryland's problem alone, or this is not felt to be Exelon's problem alone, based on what we've seen from FERC anyway. And EPA is not considering it to be Exelon's problem alone. In fact, not at all. They're looking, the EPA in cooperation with all of these groups that are identified here on the right side of this particular slide, are essentially working on this Conowingo Watershed Implementation Plan, this Conowingo WIP, to improve and improve the water quality of the bay to the tune of this 6 million pounds of nitrogen, et cetera. And it's not, essentially that obligation is not being attached to any particular population of any particular state. It's a general obligation that they're trying to pull together some type of plan to address without naming names, let's say. And this is a very difficult task, obviously. That is what the watershed, the Conowingo WIP is. It's not geographically centered like Pennsylvania's WIP or Maryland's WIP or Virginia's WIP. It is sort of an ethereal WIP that's hanging out there, that is considered to be a joint obligation. Not particularly a well-received concept, perhaps, by some. In any event, that is going forward. There was a final version. Wait, sorry, I skipped over the date. May 6th of 2021 was the final version of the generalized Conowingo WIP. And you can read a little more about it in the details here. And this gives you a little more. There's some text here that talks about what's in there. And then also here's a timeline, a little box that gives you the timeline as to the next steps with regard to the Conowingo WIP. And the next event is that there's a steering committee established, which is going to have its next public meeting February 9th. These things are always virtual, or there's virtual ways to attend, and I've attended some of them. And you can log in and hear the thoughts of the personnel that make up the steering committee, as well as these entities here on the right side of this particular slide in terms of where they're going. So there's a link down at the bottom of this slide that will tell you all this information and a lot more. Okay, Ross. Yeah,
we've reached the 3:15 time, so I think we need to wrap it up. I don't see any questions in the Q&A. I'd ask you to please complete the evaluation. The link has been posted in the chat that helps us for future programming. For attorneys, also the link for the CLE form is in the chat. I would ask that you complete that form promptly so that we can get everything submitted. I thank you all for your attendance here at the Farm Show Ag Law Symposium, and we encourage you to participate in future center programming. So thank you very much.